First of all, welcome. I apologise for the late lunch and for the delay to the start of this session. Can everybody hear me now? And I understand the microphone system is working, so welcome to anyone who's watching outside of this room. I think most of you know who I am by now, even if there's a few new faces. So I'm Louise Phillips, the Planning Inspector. Louise St. John Howe is the Programme Officer. If anyone with a mobile phone could switch it off or turn it to silent. I understand from the council we're not expecting any fire alarms, and I think everybody knows where the toilets are by now, so we won't take up time with that. If I could just remind everybody here that this meeting is being broadcast live to the internet and will be capable of subsequent repeated viewing, with copies being available upon request. So by being present here, your image is likely to be captured by the recording cameras and become part of the broadcast. This could infringe your human and data protection rights, and if you have any concerns, then please speak to the webcasting officer. And just another reminder that it's very important to activate your microphone when speaking. If I could just take introductions around the room, and then I'll explain how we're going to proceed this afternoon. Thank you.
Good afternoon, Madam. I am still Mark Beard, a barrister instructed by the Council on behalf of the Local Planning Authority. To my right is Ms Alison Blom-Cooper. To her right, Miss Chloe Salisbury, and to Miss Salisbury's right is Mr William Marheenan.
The name's Louise Steele from Framptons on behalf of Mr Padfield. Apologies from Peter Frampton.
Stuart Williamson from Wood PLC, representing the Crown Estate and their land interest at Chipping Ongar.
Richard Pesdell, Peterborough Associates, for Mr J Foles and Miss R Jamil.
Afternoon, Roger Lowry, the Epping Society. We have interests in the town but also throughout the district.
Jane Gray.
Jonathan Steele, Savills Planning, acting for Cirrus Land and L&Q.
Good afternoon, Derek Stebbing from Stratton Parker, representing two clients, City and Country and Crowdace.
Good afternoon, Richard Clues, representing Scott Properties.
Good afternoon, Madam. Stephen Whale, barrister, instructed by Savills on behalf of Crest Nicholson Easton.
Good afternoon, Mum. Martin Friend, Vincent and Gorbing, acting on behalf of Waits, who have land interests at Epping. Thank you.
Good afternoon, Ed Norris, DLP Planning, on behalf of the Farmers Club Charitable Trust and their land interests at Waltham Abbey.
Good afternoon, Madam. David Neame from Neame Sutton on behalf of Catesby Estates PLC and their land interest at Church Lane, Northfield Bassett.
Good afternoon, it's Anna Ambrosiewicz from First Plan. I'm acting on behalf of my client, Chalice Trustees, in respect of Panfield. Thank you.
Roland Bolton of SPRU, the unit in DLP Planning, on behalf of a peer group and their land interests at Northfield Bassett.
Stephen Wilkinson, Lee Valley Regional. Stephen Wilkinson, Lee Valley Regional Park Authority.
Well, thank you, everybody. This afternoon's session is effectively a repeat of this morning's sessions, and it is my sincere intention that no one here is disadvantaged by going second. But I think with that said, it wouldn't be an efficient use of my time or anyone else's here for us to relive this morning's session absolutely. And so, for example, I don't intend to ask the council to respond again in full to every question on the agenda, but rather to ask them to reply to any new points raised. If anyone feels a problem with that, if they weren't here this morning, I can always try to summarise any of the key points raised if you ask me to do so. Also, if people who are here who would listen this morning are content to reinforce any points that were made rather than repeat them fully, that would be as helpful to me and more helpful perhaps than having them just repeated. I will, however, for fairness, just repeat what I said this morning in relation to a letter received from Mr. Simmons, who was here this morning representing CK Properties in Thaden Boys, and he was concerned that I'd asked you to address points of principle, primarily concerning the site selection process rather than going into the merits of omission sites. And as I said this morning, I'd explained in my guidance note that omission sites are not normally discussed in detail, but if I were to find that additional sites were needed, potentially because of issues with the site selection process or other reasons, it will be for the council to decide which additional sites to bring forward, and not for me to decide which ones should be proposed. So it's in that context I don't want to hear details, particularly about omission sites. The implications of the CK Properties judgment for fairness and legal compliance was considered on day one under matter one, and you're not precluded this afternoon from being able to explain how or why, in your view, wrong conclusions have been reached during the site selection process, and I expect that you might do that with reference to your omission sites. I've specifically asked in both this morning and this afternoon whether changes are required as a result of the Regulation 19 and 20 consultation responses, and that could include things that were said in the supplementary representations on the site selection report appendices. And so I asked the council if they wish to comment on whether it still considers that the issues raised by the judgment could be addressed through the examination process, and said that they could reply later. They endorsed my approach for now, but I don't know if it is their intention to reply. I'll just check that with the council, but I say it's not going to change how I run this afternoon's hearing.
No intention to reply at this stage. We endorse your approach. It's not our intention to reply further from the submissions we made at the matter one stage.
Thank you. Thank you. I will also, in fairness from this morning, take the agenda in the same order and the same manner as I did this morning. So starting with issue one, we'll take the sifting, historic environment and the sequential approach together, then the capacity of sites. And that's really, as I said, it was a question directed at the council, so I don't need to hear from them again, but I only want a response from anyone else around the room if it goes significantly beyond saying that my site is suitable and you haven't used it. We'll then come on to car parks and then issue 2 and issue 3. And as I did a bit later in the day this morning, can I just take a little show of hands for who wants to talk about issue 2 relating to gypsies and travellers? No. And issue 4, viability. Okay, thank you, that's helpful. Right, in that case, we'll move straight on to issue 1 and issue 3. Have the planned housing and new employment allocations been chosen on the basis of a robust assessment process? You've all read the site sifting there. I want to hear about that now. I'll say one go each to start with. The historic environment. The council confirmed that the statement of common ground with Historic England has been signed. And the main question I want to hear about is the absence of heritage impact assessments at the plan making stage. And then also about the proposed modification to delete the sequential approach to the allocation of sites in policy SP2A. Does the council want to say anything before I go to others?
Just wanted to check that everybody has a copy of the overview that was handed out earlier today. The overview of the residential site selection process. If you'd like us to speak to that briefly again, madam, we'd be quite happy to do so. We're in your hands.
Was there anybody who wasn't here this morning who would find it helpful to have the council briefly outline the process with reference to their diagram? One over there. Yes, please, then. Thank you.
Does everyone have a copy of the diagram?
Yeah. Do you have a spare copy? Because I have abandoned mine somewhere. Thank you very much. Thank you.
I'll try and remember what I said this morning for interest of fairness. So the diagram provides an overview of the residential site selection process. I think I confirmed this morning that it does also broadly reflect the process that was undertaken for employment site allocations. Save to note that in 2016, the council started the site selection process in relation to employment sites and paused at stage 2, which is the amber box in order to collect more information on employment land supply. And so effectively, employment sites just went through the 2017 process. With regard to residential sites, the further detail of the site selection process can be found in section 2.2 of the site selection report, which is EB 805, and the site selection methodology, which is EB 805 AK. What the diagram seeks to illustrate is that, broadly speaking, the process was consistent between the tranche 1 sites, which are the sites assessed in 2016, and the tranche 2 sites that were assessed in 2017. The process was staged and started with following the identification of sites, sifting against major policy constraints. There are 6 of those, and they're set out in Table 1 of the site selection methodology. There was then stage 2 or 6.2, which was a site-specific suitability assessment against, I think it's about 32 or 33 criteria. Then there's stage 3, which there are a number of steps. In the interest of space, I've just said step 1, 2, 3, and 4, but paragraph 2.65 of the site selection report, which is page 23, sets out the 4 steps. I will summarise those, which are step 1, identifying suitable strategic options to accommodate growth. Step 2, assessing site suitability. Step 3, assigning sites against the land preference hierarchy. And step 4, identifying sites for further testing. Those sites that went through that process were then subject to the capacity assessment and then moved on to deliverability assessment that comprised 2 parts. The A&A assessment relates to availability and achievability, and then a recommendation on sites for allocation. The boxes underneath on the appendices line are the main appendices where the write-up of each stage can be found. Those are just for residential site selection process. Employment has some different site references or document reference numbers.
Thank you. Okay, so we'll turn to going around the table now. So if anyone who wants to speak, please put up their board, and I'll hear what you want to say about the site selection or sifting process, the historic environment, and the sequential approach. Thank you. More around this side of the table, so we'll start this side at the moment. So, Mr. Wilkinson.
Thank you. The authority considers that the council's site selection methodology is unsound, and our concern is the omission of 2 sites, which are together, Mall and Langley Nursery in Waltham Abbey. Now, the inclusion of these 2 sites for housing would have been consistent with national policy designed to protect the green belt. A few points. Mall and Langley are previously developed land. That's evident in the from anyone's site inspection of the site and from the photographs included in my statement. They have a history of commercial use for B1, B2 and B8 for around about 30 years. And this is a point which is acknowledged in the Council's pre-application advice to the authority in 2017. Both sites occupy a secluded site. It's well-treed, it's got good boundary treatment. But the site does lie within the settlement envelope of Waltham Abbey. Both sites have good access to services. They're about 600 metres from the centre of Waltham Abbey. They don't seem to have been considered because they were originally included in a strategic allocation, called that the Northwest Extension, which itself seemed to have been included in what became the preferred strategic option, the Northern option. Now, the difficulty that I have around this is that if these decisions are going to be made, they've got to be based on sound evidence. Now, in the schedule, I think it's SR 901, which I think was used for the stage 3 process, both sites are described as 90% green field, and that their loss would have a significant harm on the green belt. This is clearly not true. So they seem to have been excluded on the basis of wrong evidence. And I think it demonstrates a weakness to the whole approach, the methodology. They seem to have been largely desk-based and not evidenced by site visits.
Sorry to interrupt, Mr. Wilkinson. Are the sites in the Greenbelt?
They are in the Greenbelt, yes.
Thank you.
But they are previously developed land. And in a way, that's, they're a prime candidate for release for housing purposes because of that. Now, in further sort of evidence, in the pre-application advice that we received in 2017, the letter states that the principle of development would be considered acceptable. And despite all this evidence being sent up in advance to the council, they didn't include them. Now, set against this, using the 5 tests which determine Greenbelt, the development of Mile and Langley would not prejudice the operation of Greenbelt in the sense it's previously developed land, because no strategic importance to the rest of the regional park or the rest of the Greenbelt when you take it as a whole. And they can be delivered probably within the next 2 years. There's no covenants which restrict development. There's no tenancy arrangements which restrict development. They can go ahead. Now, if we contrast these 2 sites with those which are described as SR099 and SR0089A, these occupies a large area of land which is in agricultural use, apart from small areas, and which lie above, because they've got elevation, above Waltham Abbey. And of course, Mile and Langley would not satisfy just themselves alone the housing requirements of Waltham Abbey, but if they were developed out, you wouldn't be taking such land which is pristine Greenbelt on these 2 other sites. Because the development of these 2 sites certainly would not safeguard the countryside, going back to a Greenbelt test, and neither would it preserve the special architectural character of Waltham Abbey, given their physical prominence, their elevation over the settlement. For these reasons, the authority contends that the site allocation methodology is unsound, and Mile and Langley should be de-designated from the Greenbelt and allocated for housing. Thank you.
Mr. Bolton.
Thank you. I'm going to try and go through the individual points that you've raised in that order to be of assistance to you. And the first point is the role or the transparency and the role of the workshops, which we did hear about this morning. And I'll use the site to the south of North Weald Bassett as an example of where we think there is a lack of transparency. You will have heard, both in this examination and indeed in the submissions to you by the council, that the master plan, that's EB 1003, concludes that development to the north is preferable. It doesn't. That is factually incorrect. The final chapter, which is chapter 9, includes the site to the south, part of it as most preferred to meet the 500 units, and then the rest of it preferred to meet 1,000 units. And that's on page 149, so that's right at the end of the master plan. So the starting point, therefore, is the master plan did include development on both the north and south of North Weald Bassett. So the question then has to be asked, where was that decision made? The council do refer to the master plan and feedback in terms of chapter 7, but that was feedback from an exhibition of where they had 44 respondents from about, I think, 160 attendees. Now, that can't be the basis of making strategic planning decisions. And even if it's the basis of it, then where was that decision actually made? It wasn't made in the committee report. The committee report that reported the master plan to members reported it. Members took note of it. At that committee meeting, there was no suggestion of there being a preference to north or south. And we've taken you before to where there have been meetings between officers and members in terms of workshops, etc. But we have no record of what was the input to those, or indeed what was the outcome of those workshops. And indeed, if the master plan has been inaccurately reported as concluding that development is preferable to the north, then that actually makes the outcomes of those workshops seriously questionable. So, I mean, we do actually need, I think, the evidence of what was being presented at those and what the outcomes was, and we don't seem to have that. Instead, we seem to have a decision that's floated in with no evidence base. Now I want to move on to your third point. That was your second point. I didn't deal with the first because it's of not concern to us. The third point is sites assessed individually or as part of larger sites. Now, the council have said to you on a number of occasions that all the sites are being considered individually. And they said that again to you this morning. Now, if we go to EB 805A, page 24B, you will see that for the first time for a number of years, the council have actually assessed the correct site in terms of the site to the south of North Weald Basset. And it assesses it against a number of 6 criteria, and it passes all those. So it's described as a completely unconstrained site. But then on that same assessment, it says it doesn't proceed. So it's an unconstrained site, nothing wrong with it, doesn't proceed. And it doesn't proceed because it's classed as a less strategic option, which isn't defined at that point. It refers you to Appendix B152. But the problem with going to B152 is on page B758, the assessment isn't actually of the smaller site, it's actually of Blake's Golf Course, which isn't the site that's
Just
been...
give me that reference again. It refers you to
B15, it's Appendix B1.5.2, page B758. And so instead of assessing a site of 285 dwellings over 15 hectares, which is what the site which has been continually promoted to the council, it instead assesses a site of 2,000 dwellings over 17 hectares. Now, clearly there's going to be a difference between the two. Having said that, when you look at the 32-point assessment, it does quite well. However, if you look to Appendix 2 of my submission on this matter, you'll see that I've redone that assessment relating just to the much smaller site, which is much closer to the settlement. And that comes out very, very well when one looks at all the issues that have been looked at. And my assessment there, when I've done that, what I've done is looked at how the other sites in North Weald Basset have been assessed and applied the same criteria. So it's done by the same exercise. So here you have a site that does remarkably well when you assess it against a 32-point test, which it hasn't been assessed against, but is, falls at the first hurdle, so to speak. So the justification for the exclusion then in the evidence base isn't the impact the site has, but is the impact of a much, much larger site. And it's not just the 2,000. When you actually look at how it's assessed as if like land to the south of North Weald Basset. And that's not actually identified. When that assessment is done, there's no identification of exactly what area it is. And more importantly, when you look at Appendix 3 of my submission to you, and it's worth just taking a little bit of time looking at that, even when you look at the assessment of the impact of the strategic site, the first point that is made by the council in their assessment is they say North Weald Basset Master Planning Study considered scenario A, that's one with development to the south, to be a less suitable strategic option. It doesn't. If you go to the master plan, it doesn't use the word strategic option, and it certainly doesn't say that land to the south is a less suitable strategic option. It's just not there. And the problem is you've got either one might call them either mistakes or misinterpretation, if you like, of the points being made in terms of things like topography, where it talks about the topography of a much, much larger area. And it simply doesn't apply to the smaller area. So you have, I think, a considerable problem with an approach that rules out suitable sites. And this was a suitable site. It wasn't just identified by my clients, it was identified by the council's own consultants. So I think there's a major issue with that particular approach. And I think it actually goes down, if you like, to and if I just leap over and deal with the relationship between the site selection methodology and the SA, because it's an important one here. If they have informed each other or integrated, I mean, when we first started talking, they presented them as being integrated. But when you have a suitable site, a recognised alternative, it needs to be assessed at the same level. So it needs to have the 32-point assessment done, which wasn't done. And I think, and you've heard it not just from me, but from a number of people around the table this morning and probably this afternoon, is that there are a number of what are considered to be individually perfectly acceptable sites that are being ruled out because they are in a larger area where the council don't want to go. I don't think that's a proper way of approaching an SA.
Thank you. If you can,
I'll
you can carry on
move
with SA, but if you could move on from the sort of larger parcel. Thank you.
No, I think I've dealt with the SA. Thank you very much. Thank you for giving me the time. In terms of moving on to your point about errors, and you really have 3 points that deal with errors, and I might roll them together slightly just to speed things up. Now, in terms of errors, we've consistently said that the council predominantly assessed the wrong site during the approach they've taken. And it wasn't until we had, it's certainly the wrong site at the time of the 2016 assessment, and you have Appendix 1 in our submission, which is a note of the meeting between AREPS, the council, and my clients with regard to the site and whether it was the right site or not. And it clearly wasn't at that time. We were clearly looking at much, much bigger sites. There were other errors that were brought up. The assessment suggested, the council's assessment suggested it was best and most versatile land, but it was a golf course and it was a radio station with made ground, neither of them with agricultural use, and therefore clearly not, 1, 2 or 3A.
But does this comes back to the fact that it was assessed as a much larger parcel? Is that?
That might be the council's excuse, and if it is, fair enough. But okay. I mean, I'm dealing with the site that was promoted. My clients have been consistent in promoting the same site. There's about a dozen letters to and from the council saying, please look at the right site, please look at the right site. They've actually got a response from the chief exec saying we will look at the right site, but the only time we can find it is in the 2018 appendix that came out after the submission, whereby they looked at it and immediately ruled it out because it was in a bigger area that they didn't like. It's almost, like saying to someone, look, we know you're not guilty, but we don't like your neighbours, so we're going to find you guilty anyway. Which doesn't seem to be fair and wouldn't stand up in many places of law. So there were a number of, not only did they look at the wrong site, but by looking at the wrong site, there was then, if you like, issues about things like agricultural land value. In terms of where one goes to rectify it, an easy way out would be to effectively look at those sites which were excluded because of a policy decision, which really what the preferred approach is names in the title. It's not a environmental assessment, it's a policy assessment about where development should go. So would be to relook at those in order to see whether or not there's any sites within that that could come forward to meet what we think is a higher OAN. So there is that point to do, but also I think you need to look at the SA, because the SA I think is not in accordance with the regs at the moment. So you would need to redo that, and that would need to actually feed in the decision making. I mean, unfortunately, my view is that at the present time the issue with the OAN plus the issue with the SA actually makes a plan unsound fundamentally, and it actually just needs to restart. And I say that with a heavy heart, to be honest. But I'm not of the school which says you're better, and we've heard it round the table, you're better to have a plan. Now, bad plan is better than no plan at all. I don't want to paraphrase Theresa May at all, but you kind of know where I'm going on this. Therefore, this plan's going to set the green belt boundary for 20 years. If it's wrong, and especially if it's wrong in terms of not being able to meet identified needs, then it's going to fundamentally inhibit the proper planning of this area and the wider HMA. So I do think there is a need to, if you like, step back and have a long, hard look at where we are here. Thank you very much.
Okay, thank you.
I just want to add that we do agree with all the points that have been made already, and I don't want to spend too much time going back and forth. We do consider that the site methodology is not transparent, and the plan has not been fully justified in terms of the evidence base and site selection. There have been two sites, they actually known now as South Epping Master Plan. Both greenfield sites located in Greenbelt, there has been allocated for housing as part of the current local plan. They have been allocated for housing over Pantfield. The site, which we consider is sustainable, is located in close proximity to Epping town centre, has great transport links, and what's more important is adjoining the existing residential land, Bell Common, which we consider forms part of Epping, even though it currently is outside of the boundary. We still think that it's an important point to make, that the site is sustainable. What else? It's a brownfield site that has been already developed, and it's a very important point to add as well. And I think this point has been overlooked during the plan preparation, that it's a brownfield site that should have been promoted in accordance with the NPPF. What's more, during the site selection process, I'm aware that the Arab assessment score for our side, for Pantfield, is much more better than these two sites together. So again, it's a very important point, and we try to understand why those two sites have been selected, even though they have received a lower score. And also in terms of the Greenbelt study that has been prepared by the council. The Greenbelt function of these two sites, it's significant and stronger, and therefore the impact on the Greenbelt function would be much more higher if these two sites will go forward. Thank you.
Mr. Neame.
Thank you, Madam. Can I just start with a couple of general points of endorsement for the points that were put by Mr. Simmons this morning, and then I want to just take you to the specifics of my client's site interest and how that has been dealt with through the site assessment process, really, to support that endorsement. I think in common with the points that Mr. Simmons made, we don't have any fundamental issues with the methodology set out by the council and ARUP in the site assessment document. the issue comes down to how that methodology has been applied. Now, Mr. Simmons took you to his specific example, and I'll take you to mine, which is slightly different in a moment. But the four-stage process that was explained earlier was followed in the context of my client's site, and that was borne out into an allocation at the Regulation 18 stage. So the site in question is land at Church Lane, North Weald, Bassett. The site reference, madam, for your ease of reference, is SR0003. So that site was a proposed housing allocation at the Regulation 18 stage. In between the Regulation 18 and Regulation 19 stage, the site was removed from allocation. That brings me then to the specific points. We'd heard that this morning from the council that the basis for considering changes to those allocations was essentially where there was a clear planning reason for doing so. I think that was the council's position. And that in the council's statement at paragraph 21, it confirms that it was not due to the site selection methodology that sites were either taken in or taken out. So if we look to the specifics of my client's land interest, and certainly what I'd like to just do is compare and contrast between the two versions of the site assessment that inform both the Regulation 18 and the Regulation 19. Under stages 1 to 3, my client's site actually marginally improves on the council's assessment between the Regulation 18 and the Regulation 19, so it scores slightly better than it did when it was allocated at the Regulation 18 stage. That then takes us to stage 4, and we've heard that stage 4 deals purely and simply with deliverability. The council had more evidence before it in the context of the 2018 assessment in terms of deliverability, the continued promotion work on behalf of my client confirming the timetable for delivery, the security of the land interest and so on. So there doesn't appear to be anything in that stage of the assessment that would dictate a change. Again, still coming back to whether there is a clear planning reason for making that change. If we compare then that site with the proposed allocations as they stand now in the Regulation 19, and you'll find those in EB 805N, and for your reference, madam, they're pages B974 to B989. And if it's easier for you, I have, as you will have seen in Appendix 2 of our statement, consolidated the conclusions of those various pages onto a single sheet. What that shows you is that the site SR0003, my client's site, scores as well as, and in certain occasions better than, sites proposed for allocation in the Regulation 19 plan as it stands. So again, there's not, on the face of it, a clear planning reason for a change at that point. Turning then to the North Weald Bassett master planning exercise, you'll be aware there are a whole series of options that were considered through that process, 6, I believe, in total. In all 6 of those options, my client's site is a constant proposal as a housing allocation. In fact, it's one of the few locations that is a constant. I will just touch on the essay at this point. I don't need to take you to any specific passages, but the essay does support the conclusions as we'd heard this morning, certainly for the stages 1 to 3 assessment. And of course, that stage 1 to 3 assessment is at least parallel, if not better, in relation to some of the sites that are proposed for allocation. So that brings me to the point that I can't find any credible evidence for why the site has been removed. It contributes or could contribute to early years delivery, which of course is another potential tick in the box and a discussion that we will be having no doubt tomorrow. We're told that there are clear planning reasons for doing so, but also I think we were also told this morning that sites were removed for reasons beyond suitability. But I put really, if I may, the question through you, madam. I don't know why my client's site was removed.
What I was going to ask you, just testing my understanding of where that should be said now. EB805P. What does that say about your site? Is that the right appendix? Got the right one?
Is it the right appendix? I haven't got that one immediately in front of me, but
Because that one presumably should explain, should give the reason.
It doesn't give a reason beyond the assessment that's already been undertaken up to that point that I can see.
Do you have it to hand? Under the column entitled now I can't speak, allocation justification. It's catching. Are you happy if I read what we said verbatim? It says, the site was proposed for allocation in the draft local plan 2016. It was identified as available within the first 5 years of the plan period and has no identified constraints or restrictions which would prevent it coming forward for development. Responses received through the Regulation 18 draft local plan consultation raised concerns about the overall level of growth proposed for Northfield Bassett. Given the site's more outlying location adjacent to the west of the village and the council's local plan strategy aimed to focus development to the north of the existing settlement, enabling a buffer to be retained between the village and Northfield Airfield, it was considered to be less suitable than other sites identified in Northfield Bassett. The site is therefore not proposed for allocation. So, Mr. Nemo, just as a question to you, I can see why you might disagree with what's been written, but it doesn't seem the case that there's no explanation.
Just coming back to, I have read this section, and my comments earlier were made in the light of that. I think the important points to note is that the site sits as part of the northern side of the settlement. As I said, was considered as a constant through that master planning exercise on that basis. Excuse me, sorry. It's also the case, as I'd mentioned and I've referred to in Appendix 2 of our submission, that on a number of points relative to other sites which are part of the allocation, that the site actually scores as well as, if not better than. One of those is proximity to the settlement. So the commentary that's made in this section doesn't, to my mind, justify a departure from the council's own evidence. I'm not putting new evidence to you in terms of my interpretation. It is effectively, this is a conclusion which is at odds or out with the evidence that has led up to the allocation, certainly at the Regulation 18 stage, and doesn't, to me, appear to have materially changed. I think that's all I needed to pick up at this point. Can I just clarify that we would be coming back separately to, for example, the car park issue? Will that be a separate round? Okay, thank you.
Thank you. My comments are regarding the site assessment of parcels of the Greenbelt Review, as well as the information on site promoters that was taken account of. Firstly, with regards to my client's site, SR0020N at Paternoster Hill, north of Paternoster Hill in Waltham Abbey, it's clear that the Greenbelt Review Stage 2 assessment was carried out prior to the Regulation 18 consultation, which meant that the review was not aware of potential promoted sites and could not take account of site-specific boundaries. Instead, it relied on large-scale landscape boundaries, which in my client's case of the land, is assessed a large amount of additional land that was outside of the promoted site boundary, as well as splitting the site. So this means that the Greenbelt parcel's sensitivity does not directly correlate with the specific site boundaries sensitivity as promoted, which impacts its score erroneously. Secondly, the council have stated earlier in the examination that all emission site parties were contacted after the Regulation 18 consultation. This is not correct in the case of my client's land. At no point did the council contact the landowner, land agent, or DLP being the site promoter to discuss the potential inclusion or exclusion of the site, and nor did they discuss the reasons for exclusion. No queries were raised on the submitted evidence as part of the Regulation 18 and prior to the Regulation 18 from ourselves, that consisted of a site-specific FRA and a highways note. So the contact has been very much one-sided in terms of representation submitted by ourselves. With regards to evidence that has been submitted and potentially overlooked, specifically in the case of flood risk, at no point in the assessments or evidence base that the council produce has acknowledged or referred to any of the evidence submitted to them regarding this site, specifically the FRA and transport note. Were the site to have been assessed fully, it would have, the council would have found that the majority of the site actually benefits from a significant flood alleviation scheme, and the main reasons for the site being excluded were on flood risk grounds and greenbelt harm, both of which were assessed differently to how they could have been, with a larger parcel of greenbelt and with the flood risk assessment not being taken account of for mitigation purposes. It was also assessed on being the most versatile agricultural land when actually only a part of the site has agricultural land on it, again going back to the parcel that was assessed. So to conclude, it really, the site has been assessed by the council differently to how it could have been were the actual site, as it has been promoted, were to be assessed from that site boundary.
Thank you, Mum. I think my comments really reinforce both some of the comments of Mr. Neame, but also the comments this morning of Mr. Belton, of Pigeon, representing Pigeon Investments. As you know from previous representations and comments that I've made during the examination, we consider that the site selection methodology process as a whole is robust, but it's definitely the way it's been applied that we seriously question, to the extent that we consider that the justification for the plan has been undermined between the Regulation 18 and Regulation 19 plan. Now, you'll recall, Mum, but if you don't, I will repeat, that my clients have land about 5 minutes walk from where we sit here, on the edge of Epping, and the site SR 0071, for your note, the land at Sternard's Hill was allocated at Regulation 18 and then removed at Regulation 19. So I was quite interested in the Council's comments this morning about why those changes occurred, and as Mr. Neame has pointed out, they actually stated that they only made those changes where there were clear planning reasons to do so. You recall that when we discussed, I believe it was the Greenbelt, and certainly during the neighbourhood plan discussion that we had on matter 1, the council also commented on the consultation process. And again, I think you made the point possibly that, well, that's perfectly valid to take into account consultation responses, but clearly they have to inform on a material planning basis the actual evidence base that comes to decisions on the sites which are allocated. So I've looked very carefully at the evidence base, particularly regarding the suitability of my client's land and indeed other sites around Epping that were in the Regulation 18 plan and were removed. And if you compare the two documents, EB 801G little Roman numeral 3, which is the site suitability from 2016, and the equivalent document EB 805 F little Roman 1, I believe, which is the site suitability assessment from 2018, there is no change in the evidence base. So there is no change in the evidence base. Now, when you get to an allocation, and I would refer you to EB 801, which is the original site selection methodology, the stage 4 assessment, as Mr. Neame pointed out, was focused on 2 points, and this is paragraph 4.38 of that document. Whether the site was available or is likely to become available, and whether there is a reasonable prospect that development will be achievable within the appropriate timescales. And all of that evidence was before the council for my client's land, and nothing had changed between the two plans. So therefore, as you pointed out to Mr. Neame, the justification for changes of this sort are indeed in the Appendix 805P, and if I can summarise it briefly, yes, the comment is, after all of the evidence base, that this site was not preferred by the community, allegedly, and it stated that on balance, putting more development at South Epping was preferable, and, quotes, would better support the emerging neighbourhood plan. Now, not to be a broken record, Mum, but you'll recall that there was no local plan, neighbourhood plan. There was no neighbourhood plan that was referred to in that assessment, either at that time or now. And therefore, we found it difficult to understand why, after all of the evidence base that the council had gone through, the decision to remove the site from its previous allocation was on a basis of an emerging neighbourhood plan which wasn't even in the public domain. So that brings me on to a point that I think I heard the council say this morning, that they said actually there wasn't any member workshops before the Regulation 19 plan was published. If I'm incorrect, they will no doubt comment. But basically there was direct member involvement. And I would point you to the Regulation 18 responses of the Town Council, within whom are district councillors, because they were already considering the neighbourhood plan as what they thought was the best solution, and those representations were then taken into account by the council, and led them to basically fundamentally review the strategy for Epping. And I'm not just saying our site, but basically all of the Greenbelt sites were removed apart from the South Epping allocations. So as far as we can see, that was the only basis, and there was no change in the evidence base. That was the only basis on which, quote, consultation led to a change in the strategy. So we don't believe that site allocation, site assessment process was then adhered to for similar reasons as Mr. Neame commented upon. And if I can just conclude by saying, Mum, I would ask you to go back to our Regulation 19 representations, which included a very considerable amount of information about our site. It has less harm to the Greenbelt than the Epping South sites. It is closer to the town centre, it's closer to the station, and in particular, a very significant objection was raised to Epping South by the Epping Forest Conservators, yet we are proposing an 8-hectare country park as part of our development, such that not only will we have no impact on Epping Forest SAC, but we will have a beneficial contribution to providing more recreational open space around Epping. And this information was before the council, yet the decision that it would be removed did not take it into account. So that is essentially bringing together a whole number of strands of discussions that we've had during this examination, Mum. But finally, a point which obviously Mr. Neame also raised is that our site is deliverable within 5 years. So if you find that the trajectory is actually an issue, which we certainly believe it is, our site would positively contribute to addressing that particular point. Thank you.
Is Mr. Whale?
Yes, it is. Good afternoon, Madam. My client's site is the Pickfield Nursery site in Waltham Abbey, you might recall discussed earlier in the examination, SR 0161. Now, I propose to deal with 4 of the points under your site selection sifting process bullet point, just so you know what I'm going to cover. Before I come on to those, I was actually here throughout this morning, and it gave me a good chance to just observe and see what I regard as the bigger picture. And what struck me was that this wasn't an exercise where representatives were saying their site is better than an allocated site and trying to knock them. It was very much a theme of real concerns about the process that's been undertaken by the council. And I just noted some half a dozen or so of these process headings, if you like. You might want to jot these down. The site selection process, the lack of a heritage impact assessment, the involvement of members, errors of fact, lack of site visits, predetermination, and what's been memorably referred to as speed dates. which actually I found quite a helpful label because it tells you something of the superficial nature of those short meetings. So as I say, the theme really is one of process and very real concerns around them rather than just a beauty parade of sites. Coming on then to the 4 bullet points that I wanted to cover. The first is your question of whether sites were assessed individually or as part of larger parcels. Obviously you've heard already some representations as to this. Speaking on behalf of my own client and our own site, I can say that it was assessed as part of a larger parcel, at least until it was too late in the day. Just very briefly in terms of chronology, since 2008, the site has been promoted as an individual site. In the 2012 SLA, it was wrongly identified as a duplicate site. That error was repeated in 2016. And then it was only in 2018 that it was assessed individually. And I would understand if the thought flashed through your mind, well, didn't that remedy the earlier flaws? To which the answer is a resounding no, for these really 2 principal reasons. Firstly, that bespoke assessment was only published after the Regulation 19 consultation exercise. And secondly, as I'll come on to in due course, that bespoke assessment contained clear and obvious errors around, in particular, flood risk, best and most versatile land and greenbelt impact. That leads me, I hope, neatly into your next question. Was information submitted taken into account? Again, I can only speak for my client's site. The answer again is a resounding no. Coming back then to the flood risk point as an example, and in fact your own question alluded to this. You gave the example of evidence to show how flood risk could be mitigated. And when I read this, I thought, I do wonder if the inspector has my client's site in mind. It might have been another site, of course.
I've read the statements and picked up the comments that were being
Precisely.
made.
So I was encouraged that you'd picked it up, and you will know in that case then that we've put in evidence on behalf of or from the Environment Agency to show how there is frankly no flood risk point so far as the Pickfield Nursery site is concerned. The only area where this arises at all, if anywhere, is very close to the brook, but all the built development could be outside of that area. Moving then to the next of the 3 topics, the green belt, the council's own assessment in the 2015 assessment concluded a weak or relatively weak contribution to green belt for my client's site. We come on to 2016, somehow that assessment becomes a very high harm if released from the green belt. And my client puts in its own assessment in response to this, and we know, we heard from the council this morning, that that has not been assessed in any particular way. You inquired about this, madam, and you asked if there'd been reassessment. We were told there'd been no specific reports, assessments had not been necessarily updated, and the council said they were leaving this to the examination process, which I found rather cryptic and didn't really follow. Checking of errors, which is your next question, were errors reported through one means or another checked? Again, in this instance, the answer is no. I give the example of best and most versatile agricultural land. This site was given a red score in 2018 against this criterion, despite the fact the site's covered in hard standing former greenhouses or glass houses. On any view, it is not best and most versatile agricultural land. It's a vacant brownfield site. It sounds very much like the ex-golf course and its assessment, but here that error has been compounded. And the error or errors might not have materialised if the council had undertaken a site visit. Again, this is a point that others have raised today. You asked this morning, Madam, about site visits, and the council referred you to a couple of paragraphs within its hearing statement. I looked at that, and it seemed to me that those two paragraphs were referring to the larger parcels. I'm instructed, and I've checked and I've been re-instructed repeatedly, that since 2008 the council have not visited my client's site. It's gated, it's locked, you need permission to enter it. I've been, but the council has not. And you might know, Madam, that Savills have urged you through the Pergamon officer to undertake a site visit. I would reiterate that and urge you to visit, and the council might care to visit as well. In terms of the speed date, just as a matter of fact, so far as my clients were concerned, it certainly was not 40 minutes, it was more like a 15-minute pro forma exercise, and in any event, 2018, a couple of years later, there were the errors and problems I've gone through previously. Your last question, last bullet point, certainly that I'm going to address, is really whether any of this necessitates amendments to the submitted plan. A resounding yes is the answer to that. You know that we proposed three amendments in terms of allocating the Pickfield nursery site, amending the plan in consequence, and removing the built-out adjacent Knollys nursery site from the green belt. And then, just to conclude, I gave some thought to next steps and where you and the council may go from here. Seems to me that it really comes down to three possibilities. We just plough on regardless, possible partial review, but that would be entirely unsatisfactory. Or there's a reassessment by the council, and in fact I think three speakers this morning have already effectively encouraged this option. I needs to restart. There was the Brexit analogy a little earlier this afternoon. This morning I noted down a speaker saying the council needs to go back and reassess, and it seems to me, Madam, again listening this morning, speaking this afternoon, that there are so many process concerns being articulated that I rather suspect that you're edging towards a conclusion that that is the right course. And obviously it would be better to have some kind of hiatus and get it right and get a sound plan than just plough on regardless, and then down the line you conclude that it's not sound, which is certainly the position we take. Thank you.
Thank you. I wanted to just start with a question just on the site selection process. I do apologise if you asked this morning and don't need an answer now. But I wondered whether step 3 and step 2 were deliberately the wrong way around on the diagram, or whether that was just a typo, because it goes step 1, step 3, step 2, step 4.
For stage 6.3, that's deliberate. And we explain why in section 2.8.2 of the site selection report. So essentially, step 3 is assigning sites to the land preference hierarchy. And because the council was undertaking the assessment for the second time, and it made a decision in 2016 about the cut-offs, as they're referred to in this report, in terms of which categories of sites went forward. To ensure the approach was proportionate, step 3 was done before the site suitability assessment was looked at, so that we didn't consider sites that wouldn't be taken forward for further testing.
Okay. In relation to our substantive points, our issues are fairly simple. One is that the errors reported on some of the site assessments weren't corrected. and that the assessments themselves aren't consistent, or there are inconsistencies between some of the site reports. In terms of the errors, we've set out all of these in our hearing statement, and of course in the supplemental reps for our client as well, which is 19 LAD 0086, all relate to the Chigwell Garden Centre site. We highlighted 8 criteria that were then not corrected in site assessments. Now, one of the reasons I highlight that now is because there were corrections between the 2016 site selection reports and the 2019, published 2019 version of the report in relation to some of the wording, things like it changes from housing to residential, and there are some corrections in the notes, so clearly someone had gone through them. But the substantial corrections that we were going through for the fact-checking in relation to the scoring of sites, things like the one that comes up a lot is the best and most versatile agricultural land, but many other criteria simply do not appear to have been looked at in any detail, while there are some minor tweaks to the forms themselves. So that's a little troubling. The ones that we would include are topography, brownfield, greenfield, distance to a tube, and one that I think I should point out is the scale of development itself. So the site assessments for our site, and it doesn't necessarily matter which one that is at the moment, was considered as 40 dwellings per hectare. It comes out in our case at 220 dwellings for the site. Now, not once did the promoter of the site suggest that 200 dwellings was appropriate for this site, given the character of the area. Yet that number appears, and then the site assessment scores it down on the basis that the development would not be in character with the local area. What's troubling about that is simply that it had never been promoted for that scale of development, so therefore to score down for that scale implies that actually the council didn't really look at the submissions that the promoter was making in any real detail in order to address those points. In regards to the inconsistencies, and perhaps more importantly, we have a rather unique situation. We've got 3 site assessments for the same site, essentially. It goes from 1.6 hectares, it's a site that has been allocated in the plan for 65 dwellings, and that's Chig R5, and then up all the way up to a 7.5 hectare site. The actual promotion was for 5.6 hectares, and that's the later assessment. So those assessment references are SR 0478A, 478B, and SR 586. Now, what's helpful about our site in terms of the inconsistencies is, of course, they should be very, very similar in their scoring. We've highlighted in the hearing statement some of the areas where actually they do score differently when you would expect them to score identically in many cases, and that's compounding the errors on top of that. The ones that we would point out in particular is that so some of these sites are contained within the others. Now, one site is shown to be quoted as being 75% brownfield, while the other 2 assessments say that the site is 100% greenfield. It's obviously mathematically problematic for us, but it doesn't reflect that obviously at least a part of the site is clearly brownfield. The distances to the tube, the site that's been allocated is actually further away than the unallocated site, even though they're close to the tube, and the scores are not consistent between those. The settlement character is different for the particular sites. The traffic impact scores differently in the site criteria, even though the number of dwellings proposed on each of the assessments is approximately the same. So all of these things are just sort of inconsistencies that we find a bit troubling. Now, coming back to your bullet point, and bullet point 6, we do feel that the areas do necessitate amendments to the plan, of course, but that we could just go back through the site assessment report, go through the fact-checking and make sure that particularly those sites that were rejected from the plan are actually reflected accurately in the SSR.
Can I take you to 2 of the inset plans, settlement plans, actually in the submission plan, Madam, whilst I talk through a couple of points with you? The first one would be Lower Shearing, which is map number 5.21. And that comes after page 165. It's a few on from 165. Correct. I'm talking to you about a site that lies just northwest of the plan's allocation, which is LSHR R1. And I think the point I'd like you to understand is, well, if LSHR1 has been allocated, why has the site that Mr. Stebbing is about to talk about not been allocated? And it relates to the site assessments that has been undertaken. The site I'm talking to you about has been ruled out as being beneath the minimum 6 units necessary for allocation, having been in the 2016 assessment assessed as having a capacity of 14 dwellings. In fact, we have submitted plans to the council that can easily support the development of at least 6 dwellings, and probably 7 or 8 with ease. Further flaws are that the site has been assessed as being over 1,000 metres from the nearest primary school. In fact, there's a primary school in Sawbridgeworth, and this is a key point about this, and you'll notice that the district boundary is right at this point, and the town of Sawbridgeworth goes away to the northwest. Primary school well within 1,000 metres. Same point, madam, on a secondary school. The site has been assessed as being more than 4 kilometres from a secondary school. In fact, there's one only 1 kilometre away. And the facilities I'm talking about are mainly in Sawbridgeworth. GP surgery, again, assessed as being more than 4 kilometres away. There's one less than 1 kilometre away. And I could go on. The second site, madam, is in Roydon. And that's plan 5.15, which lies in the plan just before page 157. Talking about here a parcel of land that lies north and east of allocation ROYD R3. That allocation is actually one small part of the site that my clients have a development option on. It's actually allocated for 14 dwellings in the plan. And you might actually ask, is that a sensible capacity? And in fact, that I think will be a challenge to deliver 14 dwellings on that site, bearing in mind the character of the surrounding area. But in this case, the wider site, just for your reference, SR0890, should have given you the reference on the Lower Shearing site, by the way, which was SR0121, has been ruled out as being not adjacent to the settlement boundary. I think under any interpretation of the settlement boundary of Roydon, in that part of Roydon, that cannot be supported as a reason for rejection. Thank you.
Thanks, Mum. Having been here this morning and this afternoon, I'll keep this very short. Just for the point of record, my client would like to support many of the points made this morning and this afternoon, particularly on the transparency point, the apparent lack of reporting, engagement and consideration of the Reg 19 submissions, and importantly, the technical evidence that supported those, which my client also submitted. The Council made one point this morning, a point of clarification, which was helpful in that the site selection did assess individual sites and not the wider parcels in the site selection process. But in my mind, it's still very clear that the evidence base shows that either an assessment of a wider parcel, i.e. in the Greenbelt assessment, or if you're part of a less favourable strategic option, has influenced the decision making very, very early in the site selection process. And this is very much the case for our site, which is SR 0315, which you can see concluded in EB 801B, Appendix B1.1. Thanks, Mum.
Good afternoon, ma'am. I'm not here really to, to full on promote my site, but I want to concentrate on the inaccuracies. And in a sense, I'm obviously not a planner, but it's been really comforting to hear that other people have the similar sort of inaccuracies as I do. I thought it was just me. I also didn't get speed dating with the council either. My site, which is 0596, I got a really big dirty red minus for being next to Latin Woods, ancient woodland. My site is on the edge of Harlow Park. If I want to walk from my site to Latin Woods, I have to go through Harlow Park, which is a fair old bit of chunk of woodland. I have to go over a field, over a dual carriageway, over another field before I get to Latin. Latin Woods is near Latin Priory. I mean, clues in the name. So obviously the scoring system matters a lot, and I'm scored massively down on that, yeah? As a member of the public, I find the trying to work out, I understand, I looked at the ARAP things. My nearest, they do admit here on where it says 4.1 Brownfield and Greenfield, that I'm 200 metres from the existing settlement, which is Potter Street. Okay, Potter Street has a chemist, a GP, a primary school, a Baptist church, church rooms, hairdressers, fish and chip shop, bakers. It's quite but it's all in a little block, bus stop, everything. It's all there. But looking at the ARAP scoring, my nearest bus stop is 400 to 1,000 metres away. Nearest employment is 2,400. The nearest local amenities are more than 4,000. The nearest infant school is 1,000 to 400, as is the nearest GP. But Potter Street is 200 metres, they say, in just further down the page. I can tell you it's 10 minutes walk. I have no idea how many metres that is. But it's all there. So why is this, the huge 200 metres to more than 4,000? I don't understand why that inaccuracy is there. So that means the scoring basically is suspect, isn't it? So that makes me query about what else is wrong in the plan. And there seem to be, it's like banging your head against a brick wall here. There seemed to be no way of correcting the information and the scoring and finding out why my site had dropped out. I think it was stage 2, stage 3, whatever. I couldn't sit down with somebody from the planning department here and say, why is my site dropped out? What's wrong with it? Is it inaccurate? There wasn't a way of doing it. I had a breakthrough in January 2018. Mr. Mar Heenan from Epping He actually acknowledged that my site was not an active football pitch. My site can be seen from two public footpaths and from the road. You would see goalposts. Nobody's been to see that site. They don't even have to ask me. They can go and look. Nobody's been there. But he did say that at that stage, he said, yes, actually, although we've got it all wrong in the error in the SHLA, because there was something about an overlapping site as well, that's not affected how the site has been assessed. And we'll try and get the football pitch ruled out. But he also says the council is currently finalising the write-up of the site appendices, but this is unlikely to be before the end of the publication period. The council considers that the suite of evidence-based documents available is adequate. Clearly, the write-up will not change the submission of the local plan. So whatever I said wasn't going to make any difference. Okay. Second part I want to say, and I have no idea whether it's the right place to say this, I was really disappointed with the ARUP scoring system. It's so old-fashioned. There was nothing in there that I could score to say that I wanted to do sustainable housing, water recycling, super-fast broadband. I wanted on active design principles. I mean, I could go on electric car charging points, etc., etc. All of that should be in there. That should make up the score that makes sites desirable and sustainable, yeah, in this day and age. Oh, and of course, the water recycling, which is hugely on trend today. You know, we're going to be so short of water. So there's that bit. My other very end point, we've been talking a lot here about, I was here this morning and hearing about the tubes and this, that and the other, and everybody thinks you can hop on a bus and get into Epping or wherever, or into the thing, town, whatever. But an ARUP talks about bus stops. Great idea. We've got 2 bus stops in the village where I live, 5 miles from Saffron Walden, but no buses after 2:30. Ridgeon's site in Saffron Walden, Law Homes, put in, they got permission to build houses. First thing goes in, sensible access road. Second thing that goes in is a bus stop. Fantastic. Then they start building houses. Okay, so this was in September 2017. Lovely bus stop, you can sit in it, absolutely brilliant. No bus. It's not, and there's no, the Essex County Council bus guru, who I raised the Ashton, where I live, the bus issue with, says there are more cuts to come. There's no way. We're going to have less buses. So you can go to work, but you can't get back. Do you see that it's no good looking for a bus stop. You need buses. Okay, so I think there's a lot wrong with this assessment. I would really welcome 10 minutes with a planning person from Epping District Council to sort out some of these. This could have been done so early on, and it could have been, the correct things could have been put in there. That as you know. So I don't think the plan is sound or transparent. So thank you for your attention.
Mr. Lowry.
Thank you, Ma'am. The bad news is that last night, at a committee meeting, we wrote down a list of 27 points. The good news is that, courtesy of ladies and gentlemen here, and we also cancelled a few because they were very NIMBY, but courtesy of you, most of our points have actually been raised by your good selves, and I'm sure suitably acknowledged. But I do have 5 outstanding, smallish items, most of which end in questions. So I'll zip through them as quickly as reasonably possible. The first one is about the role of consultations in the process. As a society, we have made lengthy and detailed and weighty contributions at pretty much every stage. And we know from the website that the general public and local voluntary and statutory bodies have also deluged the council with many, many contributions, all with their LA code numbers and so on, and RES code numbers. Now, some of those appear to have been listened to. We heard mention over here that a site was rejected because it met with considerable public concern and there were reason points made, so the council threw it out. My question on the matter of consultation is the process is not clear. There appears to have been some sort of black box into which all these public consultations went, and then results came out, sometimes to ignore the consultation, sometimes to listen to it and change the plan, sometimes to actually change sites. Now, I know it's not strictly part of the official planning process, but if you are going to use public consultations, as seems to have been the case, there should be a consistent and transparent process so that we can know how those contributions have been used. For example, have they been put into a scoring system? Has an independently commissioned planning report or reassessment scored 5 points? Has one little old lady moaning because she can't walk her dog scored 1 point? The data's gone in, but we can't find anything in the published documents about how the consultation feedback has been used. And by the way, ladies and gentlemen developers, we haven't even had a speed date. My second point is about the matter you raised, Ma'am, which is the transparency in terms of the members, the councillors, I presume you might be referring to there. There is a webcast out there where councillors are trying to raise objections to or suggest changes to the process and some of the site selections. And they are told categorically by a planning officer there is no time to make changes to this plan. A Brexit scenario. A councillor then went on to say in her presentation to the camera, it feels rather like you're holding a gun to my head. Now, if the planning process is being operated like a gun to the head, what confidence can we as the public, which is effectively who I represent, feel that this is a sound, fair and well-judged process? And that is a question. My third point concerns Epping Forest. Now, in the local community here, we have always had an understanding that the area of Epping Forest is pretty much sacrosanct. It's governed by the City of London. You'll need an Act of Parliament to make any changes, and so on. The Infrastructure Development Plan, which is part of this plan, has got a number of mitigations to roads and junctions. Now, these will be fairly crucial if we're not to see our already present roads and junctions, which are dire at the moment, get worse. The ringway projections, 38, 42, whatever percent you look at, depending on the scenario, but they're all talking about a lot more traffic. And by the way, don't give me modal shift because these offices don't have a bike rack. So the question is, how secure is the local plan in ensuring the cooperation of the forest in those various mitigations? Because if we can't get bits of forest to improve the junctions, the roads will get worse, and all your lovely houses, the people won't be able to get in or out of them by car. My fourth point is employment sites, which is part of the remit of this session. The last map I looked at had new employment sites distributed rather unevenly through the district. This seems a shame when part of the objective set out in the plan is to find work that people can get to without having to travel very far. At the same time, we see a possible loss of Loughton hire buses. We see the site at Bower Hill here in Epping, which, although it's presently derelict partly, could be resurrected and create employment, but that is planned to be reallocated towards housing. If we have an unequal distribution of employment sites through the district, that will also increase journey to work. And my last point is linked, but is also about sustainability. Sustainability figures high on the MPPFs and on the plan's objectives. I would really like to know how high a weighting it got in all this lot. Points made by Mrs. Gray here about eco developments and so on are relevant. but particularly about site selection. Why on earth have some sites adjacent to tube stations been rejected and other sites which are more than a kilometre away been accepted? Thank you, Ma'am. Thank you, folks.
Exactly.
Thank you, Madam. Just a very short comment. I watched the webcast this morning, and I only wish to very briefly address your bullet point 7 on the relationship of the SSR with the Habitats Regulation Assessment, the HRA. In listening to the webcast, I heard the Miss Blom-Cooper from the council say that they would prefer to defer it to the May hearings when the new HRA, the 2019 EB 209 document will be looked at in more detail, and we would concur with that. The only thing I wanted to really therefore say at this juncture was that in terms of integration, we are really concerned that that could not really have been achieved because, as our Regulation 20 response pointed out, the 2017 HRA document EB 206 was not rigorous enough and failed to identify the scale of change which might affect the special area of conservation. In particular, it didn't lead to an appropriate assessment. And of course, that has moved on with the new HRA, which we'll look at in the May hearing, I hope. But the fact that there was not an AA at that time, the HRA at the time just simply tried to rule out the likely significant effects rather than following the required steps as required by the habitat regulations. The other issue that follows from that was that mitigation wasn't really looked at all clearly in relation from that HRA, and therefore in relation to this quantum or the distribution of this built development. There was not a clear strategy drawn out at the time. Indeed, that lack of clarity was shown up by the fact that the ZOI, the zone of influence chosen, was a rather arbitrary one of 5 kilometres in that particular HRA, which we know subsequent to that has been shown to be 6.2 to be different from what was chosen. So there was a lot of vagueness within that HRA, and therefore, whether it was integrated or not, it leaves something to be desired, and the concern is whether the integration really was there. And on that integration point, the particular concern the Conservatives have reiterated a number of times, of course, is on 2 points on green space mitigation. The HRA at the time did not assess whether the level was adequate and whether the quality was sufficient. That was not in the HRA document EB 206, and therefore it didn't really address that issue with the quantum of development as a whole. And then the final point really is clearly something we've raised in the February hearings and no doubt raise again, which is this quantum of development in the roads infrastructure. We've just heard from the previous gentleman from the Epic Society about that, and of course I won't go into detail on that because that's something we'll want to explore because, again, the Transport Assessment Report, which also has only just came out in January, is linked very closely to HRA, and again, there was no detailed assessment at the time when the spatial strategy, the site selection was being done. So there are lots of problems with, I think, what was there at the time when the evidence was drawn up, and we'll wish to revisit that in May, I hope. But we just wanted to flag that up, that we've got concerns over that now. Thank you.
Thank you. Slight change of track to employment before I come back to housing, so a bit refreshing for a second. Just employment to start with. As you'll be aware, employment and looking for employment sites works very differently from housing because, in summary, a housing site is largely homogenous. They're normally the same. Whereas in order to identify a portfolio of employment sites, the very first step is to work out what you need or what you want. Now, the NPPF, which we haven't talked about today, but the old NPPF set out a logical structure between paragraphs 160 and 161, where logically paragraph 160 requires the planning authority to develop an understanding of its quantitative and qualitative need, so it knows what it's looking for. Now this in shorthand is normally taken to be the council's employment land review, but that is the requirement at 160. 161 requires you to use this evidence to go and identify your portfolio of land. Now, the fundamental problem we have here, and we have always made, is that the council did not get round to undertaking a full employment land review until December 2017, well after the site assessment process had commenced and the council started making judgments about the suitability of both employment and housing sites. They did not have the evidence in place to undertake the assessment required by the MPPF until the plan was submitted. So with the soundness hat on, it's very difficult to see that the site selection process can be sound, given that we didn't know what we were looking for. And a strategic warehousing site, the need, the type of site you may be looking for, if you are looking for a large warehousing site, of course is exceptionally different to the type scale, location you're looking for offices or small industrial. And we did not have that evidence. So that's employment. Just a minute on housing. Some of these have already been made, but I'll just make them in relation to our client site at 158B. Now, 3 simple points. First of all, as we've heard many times, the site actually assessed by Arabs does not actually reflect the site promoted to the council. The site promoted to the council has never been as large or as extensive as being assessed. The practical problem with that for the site assessment is that the land being promoted for development has picked up, shall we say, negative attributes from land unconnected.
So is this again in the sense of the less preferred strategic option rather than that it's the wrong site boundary?
It is the case that the whole land parcel 158B, part of that parcel is slightly susceptible to flooding. But that land has never been promoted for development to the council. But when site 158B is assessed, it is slightly downgraded because part of the council's site is liable to flooding. But of course, the land we're always talking about, we've always submitted some flooding evidence to say that the parcel we want to develop is not susceptible to flooding. So the point our client has always asked us to make is why the council has not split the site or reassessed the site to take into account the land that is actually being promoted and the constraints that apply to the land actually being promoted. Now, I give you flooding as a very, very obvious example because that can be mapped. So you can see how one part of a large land parcel is susceptible to flooding, but the other isn't. Now, this flaw runs through all the rest of the analysis, whether it be protected hedgerows on one side of the site or another feature on one side of the site. The key point is that it does not actually contaminate the land which is being promoted for development. And the council has never stood back and redone the assessments on the land that is actually being promoted for development. So sites have been thrown out of the process because they score negatively on land not actually suggested for development. So that was part of the assessment process, and our clients put flood evidence in and other evidence in to try to see if the boundaries could be adjusted or the assessments redone. The final throw is my understanding, and it is a very complex evidence base, as you will have worked out. To be honest, I've never seen something quite as extensive or complicated as this, but my understanding is that the site remains omitted because it failed tranche 1. Now, the reason the site failed tranche 1 The primary reason it failed Tranche 1 was because at the time it was more than 300 metres from the built boundary of the village. Now that was the case at the time back in 2016, but now in 2019 the council is proposing to allocate the land immediately to the west of our site and land very close to the east of our site. So the site assessment, the rationale for not taking this site forward as part of the final portfolio simply no longer holds true. But that site assessment, based from 2016, hasn't been updated. Nobody's re-looked at it to think, hang on, the reason it was omitted was because it was 300 metres from a boundary. Now we're allocating an employment site this side and housing that side. With hindsight, this is not actually such a bad isolated site as our assessments would make us believe. Now that, of course, we only found out in January. But there really needs to be a common sense look back through some of these sites that were omitted at earlier stages, because especially in the case of this site, you'll notice in Newton Bassett, there is a wedge essentially that comes down between the council's employment site and the proposed housing sites. No greenbelt logic for it. All the analysis suggests the greenbelt is weak in this part of the world. There's no defendable greenbelt boundary here, but this rounding off of what would make a sensible site doesn't seem to be done in the rush to submit the plan.
Thank you, Mark. I'd just like to reiterate some of the concerns raised about the robustness of the site selection process and how this impacts on the soundness of the plan. I think, having reviewed the evidence based on the plan, I think it's obvious that the plan as submitted isn't sound. It fails the test of justified, and the council hasn't adequately demonstrated that the plan represents the most appropriate strategy when compared against other reasonable alternatives as set out in paragraph 182 of the NPPF. I just want to pick up on a few issues which demonstrate this point. The first of those is the fact that the sites seem to be determined by the longer-term identification of the site rather than being determined by the evidence and being allocated through the evidence base. And I just want to use the example of flood risk to demonstrate this point, and I appreciate you've looked at this issue. But document EB 913 identifies 6 sites that are identified as being in areas with flood risk. But really, the council should have applied a sequential approach from the onset of the plan in line with paragraph 101 of the NPPF, where it should only consider sites that have flood risk if there are no reasonable alternatives. Only then should they, through the exception test in paragraph 102 of the NPPF, consider whether any sustainable development objectives which outweigh the flood risk considerations. The Environment Agency raised similar concerns in responding to the local plan in 2016. But the exception test was only applied in March 2018 through document EB 913, which was after the submission version of the plan was published in December 2017. So it's clear evidence that the council's identification of sites has been determined through the longer term identification of those rather than being informed by evidence. So I think in doing so, they've fallen into the Doncaster trap, as I'll call it, and I've included the inspector's appeal letter on the Doncaster local plan in my representations. But in there, the inspector determines that the sequential test is a high bar. It should be impossible to find sites outside flood risk, not just preferable. The inspector also determines that the allocation of land should only be, flood risk should only be identified in exceptional circumstances and clearly justified. And he also concludes that no objection from the EA is not the same as passing the sequential test. It's really for the local authority to apply that, and they haven't done that through the onset of the process properly. I think the second point I'd like to make is there are clear examples, and you've heard some examples today, where the evidence base just hasn't justified the approach that the council's taken. And I'm just going to draw on the example of the Greenbelt assessment and sites at Chipping-Ongar for this. The council site selection report, EB 805F Mark 3, identifies 4 sites on 1, 2, 4 and 5, where the report concludes that the level of harm to the greenbelt would be high or very high. And in some cases, it requires mitigation to provide a robust and defensible boundary for a greenbelt revision. Conversely, it's identified my client's land, SR0112, as having a very low or medium impact on the greenbelt, but it isn't proposed for allocation. Instead, the council has decided to take a piecemeal approach to the erosion of the greenbelt through the allocation of various sites, rather than taking a long-term approach which could have been taken through identifying sites at lower harm to the greenbelt. Now, the council in its report sort of suggests that this reflects a sustainable development criteria and the need to, or the desire to locate sites further north, nearer to the town centre. But there's some clear inconsistency in its approach, that it's identified lands immediately to the east of our site, which is identified as being a sustainable location for development. And it's also not taken into account of the fact that our client's land is immediately next to a primary school. The site report actually identifies it as being 1 to 4 kilometres away from a primary school. It actually borders it directly. It's connected by a footpath. That footpath can be upgraded. And there's a clear benefit, given the trip generation from primary schools, to co-locating homes with a primary school. I don't think that's been adequately taken into account through the inaccuracies in the report. I think you've heard, again, numerous occasions this morning where there have been inconsistencies in the way that sites have been assessed or the conclusion of the reports. And I just want to draw on a couple more, if I may, with regard to bat habitat. Now, with regard to my client's land, document EB805P concludes there are no identified restrictions which would prevent site SR0112 coming forward. However, it was considered that the access could not be achieved without causing harm to identified bat habitat. This is in contrast to document EB805F Mark III, which concludes that the site is likely to affect bat habitats, but the effects could be reduced through mitigation. Then a separate document correctly identifies that the site, document EB708, correctly identifies that the area of land in question that would be needed to take access to my client's land is outside the bat habitat. So there's clear inconsistencies between the council's own evidence base in the way it's identified the impacts of bat habitats, and it's correctly incorrectly identified that our access would go through a bat habitat. This also varies from the approach taken on other sites in Chipping Ongar, where also sites, I think R1, R2 and R3 are also considered to impact on bat habitats, but the issue is not seen as insurmountable, that that there are issues that could be dealt with via mitigation. So I think all of those three strands really identified that the council's approach isn't justified, it doesn't stand up to scrutiny, and the plan in its current form can't be seen to be sound, because the plan isn't adequately justified and it's not the most reasonable strategy compared against reasonable alternatives. So I think, there are clearly flaws, and reiterating comments made by other parties both this morning and this afternoon.
Thank you. I'm going to reflect and echo a bit Sawdust this morning, and I'm going to be a lone voice of positivity. In my view, the site selection process has been robust and has been fit for purpose and is sound in accordance with paragraph 182 of the MPPF. I think this will be a matter that we will discuss when we come back in May, but I just wanted to point out with regards to my client's site, which is allocated site EPP R1, as I've set out, and I can refer you to paragraph 1.13 of my statement for matter 5, the site has consistently been identified as being suitable for development through the site selection process. Thank you.
Okay, thank you. Just give the council an opportunity to come back on anything that it wants to there before we have a short break. Okay. Can I just seek some clarification on this matter of the larger parcels again, in relation to perhaps what Mr. Pestel was saying? Is it the case that sites have received negative scores on the basis of being, potentially received negative scores on the basis of being part of a wider parcel, and have therefore been screened out because of that, and Mr. Purcell would say it had scored wrongly, for example, in relation to flood risk? Or is it the case that they've all been scored on their own basis, but then a wider policy-based decision has been taken to screen out whole areas regardless? Because the two seem to me slightly different. It would seem I can understand whether people agree with it or not. I can understand the rationale behind a decision to look at all the sites and then take a broad strategic decision as to whether the sites are good or bad, but if they're in the wrong place, you can remove them. But if they've been scored wrongly because they're part of a wider parcel, whereas you've said they flood when they don't flood, that's perhaps a different matter. Perhaps if you could clarify that for me.
My understanding of the point being made was it was different from both of the propositions that you put forward. My understanding is that Mr. Pestel was saying that the site which the council has assessed is doesn't contain the correct site boundary, and instead his client's promoting two smaller sites. I may have misunderstood that, but I thought that's what he was saying, because he talked about why didn't the council split the site to remove the area of flooding. So I think my understanding was it was more a comment in relation to the site boundaries of the site that the council has assessed, and on that basis he disagrees with the assessment that has been given to the site that was assessed, rather than your question about wider parcels or strategic options.
Right. Sorry, just to give you the example, for site 158B, in the council's assessment, the comment for the site was site within flood zone 2 and exception test not required. It then goes on to give a commentary about the flood risk for the site, and it scores it 1 positive in this assessment. However, the land that was actually promoted, we provided technical evidence to show that it did not flood. So it should not have been contaminated by the eastern part of the site that did. But it still was, if that makes sense. You've got a west part of the council's parcel, which doesn't flood. Yeah.
So how did the council's parcel get created then, if it wasn't submitted?
The council created it. Yeah.
Sorry. My understanding is we're talking about SR0158B, which is a site, whether or not it is the site promoted by Mr. Pestel's client or not. It was a site that was assessed as opposed to some of the discussions we've had earlier today, which were in relation to strategic options that were determined as part of stage 3 of the site selection process.
But there's obviously a dispute here over why did you assess that parcel? Why did you assess that site if it wasn't the site that was promoted? I don't know. Sorry, I don't understand.
I think we need to go back and check the council's records, but obviously a site wouldn't have gone through an assessment that the council didn't think had been promoted, so we can go back and check our records and get back to you on that, but it didn't. Beyond that, I don't think there's much more I can say at this point.
Do you know why? Whether you disagree with how it was created or not, do you know why it was created? It seems odd that you would submit a site and then they just draw an extra bit on.
But it is in the long distant past. I honestly don't know. But in our representations we've made to the council site assessments ever since we've seen them, we have said that this part of the site, your site, does not flood, and we are not promoting that for development. Can you please take this into account?
Okay, we'll leave it there. If the council could check for me how that parcel was defined. I'm not going to take any more, because I said I wouldn't, unless you're going to clarify the answer to that question, because I haven't done that for anybody else. I'm not going to go around again, I'm afraid. Sorry. Thank you. Okay, thank you. Right, we'll have a short break, and then again we'll come back to discuss really essentially the car park sites. So we'll see is there anybody that wanted to comment on the capacity of suitable sites. I say I've already had the council's answer, and I know that. Are you going to say raise hands if you want to comment on that?
Sorry, the car park sites, ma'am.
Car parks we're definitely going to discuss. Okay, but as I said earlier, I asked a question about why more sites weren't allocated essentially, and I don't want everybody to just say yes, okay, but mine's available. So I think we can leave that question and we'll come back in 10, 15 minutes. What do you need? 15 minutes. We'll move on to car parks and then issues 2 and 4 before we finish. Thank you. Okay, so it's 1:45, so we're going to make a start. Mr. Beard.
Madam, I think we might have been slightly confused right at the end of the last session, certainly in terms of dealing with the question you asked. And I think we got a little sidetracked dealing with Mr. Pastel's site as an example. I wonder if Ms. Salisbury might just explain, in answer to your question, about the council's approach. For example, I think you put to us, or you asked us the question of whether or not we were dealing with sites compendiously or screening them out by way of dealing with larger parcels, or whether we were dealing with them having regard to particular issues. And I wonder if Ms. Salisbury might just have another attempt at answering the point that you raised.
Okay. Thank you. And then after I've done that, there's just one other point that I'd like to pick up from the previous session, if that's okay. So I think what we've been trying to explain today is that sites were individually assessed. However, when sites got to stage 3, step 1, they were considered as part of wider areas that had similar characteristics. And through that, the strategic options were identified as more or less suitable, and the justifications for those strategic options are written up in Appendix B1, 0.5.2, which I think is EB 805I. I've just misplaced my sheet. So hopefully that answers the question that you were seeking a response to. The other point that I just wanted to raise was in relation to the sort of general points that have been made around the table around the factual inaccuracies or errors in the assessment work that the council has done. And what we wanted to say was that based on the work that the council has done thus far, and a sort of preliminary review of the hearing statements that we've been able to do within the time made available, we're confident that the errors identified were either not determinant in the decision not to allocate the sites in the local plan submission version, or where, for some of the particular points picked up, they are addressed in the write-up, excuse me, in the site selection report and its appendices.
Thank you. If we move on now to discussion of the car park sites, and then we'll just have a quick catch up at the end if there's anything that's been missed. The council, just for the benefit of anyone who wasn't here this morning, just very briefly, because I won't ask the council to raise their points again, they referred to the feasibility and viability work done on these sites in their document EB 803 in appendices 7 and 8. Is that right? Yep. And they're proposing to amend policy wording in relation to the place policies, I think, and it will come through matter 15 to clarify the parking provision requirements in policy. And obviously we have on here the proposed amendment to Appendix 6 in relation to how short-term disruption would be dealt with. The council also clarified that the form of development likely to be envisaged on Loughton R1 and R2 is sort of very low-rise, flattered development, although obviously you will have heard that some people took issue with that assessment, but that was the council's position. So on that basis, if we go around the table, and then I can ask the council to come back on anything that you want to say. Anyone over this side, does it want me going the other way round this time, or no, happy? Good. Okay, then Mr. Neem.
Okay, thank you, Madam. I'm conscious of the time and also the discussion we're going to have tomorrow, so I'll keep this very, very short. Firstly, just to endorse and commend the evidence that was presented by Mr. Taylor, QC, this morning. So I don't want to go over anything that he has already covered. And then just to say, as a precursor for tomorrow, I will come back to the car park points, and particularly in the context of supply, footnotes 11 and 12, and in turn Annex 2 of the 2019 framework tomorrow. So I will leave it there today.
Thank you, Mom. Obviously, we've had quite a lot of interest in the 3 car park sites in Epping as part of our work in Epping and engagement through the local plan and indeed the neighbourhood plan. So I just want to pick up probably 3 or 4 points. In our submission, these are really quite problematic sites to deliver, and I do note that even in the council's trajectory, they are pushed out by quite a few years in order to try and resolve some of the issues that they raise. First point is that obviously there has been considerable objection to these sites, and I think the council in making various comments on various sites, including our own, saying they've taken into account public consultation. Well, the public consultation, as far as I'm aware, on particularly the railway station site in Epping, but also the town centre car parks, which are behind the high street, not far from where we are now, have raised considerable objection. The viability and feasibility information, which is in the appendix, which the council has pointed you to, in our submission is very high level. The diagrams that have been used in order to determine the capacity of those sites are that. They are diagrams. They're not feasibility studies, as I would understand them, to be done with some architectural input in order to determine the capacity of those sites. And I would ask you not to be seduced by the visualisations, because the visualisations are actually pretty easy to do. And I say that because I work with a load of architects all the time in our office. But actually showing that that number of units can be achieved and that level of car parking can be achieved needs detail. And there is no detail in the evidence base as far as I'm aware. And so I raise considerable concerns about that point. The viability information, I totally agree with Mr. Neem. I think the evidence from the client represented by Mr. Taylor QC is quite significant, and indeed the viability information in the council's appendix is, again, because it's based on the feasibility work as well, which I potentially think is flawed, I think that must be brought into question. The point about the temporary loss of car parking is actually quite fundamental. You only have to come here and try and park to know that that is a major concern. And a lot of the representations to the local plan have been from retailers concerned about the impact on a temporary basis in terms of the impact on the high street, and also because of the considerable pressure on Epping Station as to how that is going to work if and when development takes place. And I would point you in the direction of the representations of TfL, who I think were down to appear today, but I don't think have been here. And I'm quite surprised by that, because a lot of those issues are really TfL's issues, because how are they going to maintain the car park whilst doing this development? And as far as their representation goes, which I will just get before me, if you excuse the pause, their representation on this point about how we deal with the temporary issues around development is one paragraph, and it does not provide a solution. So they have various options. The options to reduce disruption might include assessing if there are other station car parks where commuters could be directed to, if there is other land available from TfL in the local area suitable for temporary parking, or phasing the development to enable part of the car park to remain available for commuters. Those are fundamental issues which go to the heart of whether those sites are deliverable. in my view, because they need to have car parking retained on a temporary basis as well as long term. Now, if I was promoting that site, I would have demonstrated a solution, and I would have demonstrated a feasibility scheme to show that site is deliverable. And I am perplexed as to why that evidence is not before you. And I completely understand the council's attempt to try and use previously developed land within Epping, which is totally understandable, but the sites they have chosen, including those 3 sites, are very difficult to deliver. Now, I have one final point, which is really a question for the council, and that's to do with the Baker Street and Cottage Lane car parks. And I refer to EB 803H, the appendix to the site capacity studies. And I'm a bit in the dark as to why that assessment looks at the 2 car parks in Epping and why it only shows one of them being developed and one of them remaining as a car park. So basically, the site that's shown as a development is shown with 37 units, and the Baker Street car park is shown as just retained as a car park. So all the replacement car parking will go on that site. So that seems to me to show there are at least 37 houses missing, units missing, from the 2 residential sites which are allocated in policy P1, which are R6 and R7, which combined should deliver 78 dwellings. Yet Appendix 8, EB 803H, at page 11, only shows 37 dwellings, with one site developed and the other site being retained as a car park, with the replacement car parking from one being replaced on the other. So that's a question, really. Where is the feasibility to show 78 dwellings?
Does council want to comment on that?
Yes, obviously the settlement capacity study was one piece of evidence that fed into the site selection process. We didn't just take what it said and just pull it straight through. And we did, as you will appreciate from the conversations earlier, we did our own capacity assessment for the sites that went through to the final stage 4. And we considered that more homes could be accommodated on those 2 sites with basement or undercroft parking. And so we took a different view. The settlement capacity study was merely to look at whether or not those sites were feasible to be developed for housing and retain the parking.
Could I just come back on that, Mum? Sorry. I mean, if that's the case, and a different form of development was being suggested in order to up the numbers, for instance, undercroft or underground car parking, that would go to the viability of the scheme, which hasn't therefore been assessed. So therefore that reinforces my point that these sites, which are problematic, haven't really been properly assessed for the deliverability. Thank you.
Before I take the next couple around the table, it's just occurred to me, obviously I just want to check my own understanding of something. In terms of the station car parks, you're saying that there'd be a requirement to demonstrate that existing parking for commuters could be re-provided. Is the same the case in relation to R6 and R7, the sort of the car parks that are not station car parks? Would you be intending to retain car parking for shoppers?
Yes, we would be.
At the same level?
At the same level as currently provided, yes.
Thank you. Mr. Lowry.
Picking up on some of the points about car parks in this town, those of you who've come by car will know that parking is dire. The station car park is usually full by 6:30. People park in outlying roads. I've got a guy near me who drives to my road parks, gets his bike out of the car and cycles down, which is over a mile. I don't feel the council has taken imaginative enough looks at this. Rather than just build a bigger one or ban parking from the streets, what about increasing the number of people using the car park by insisting on multi-occupancy cars? They could do that now. What about a big park and ride at North Weald? Been suggested by the community over and over again. I'm sure there are very good reasons, but the situation is getting that critical. And we add a mix of new housing, some of whom will not modal shift, some of whom will try and drive. It's going to get worse unless the council really does think outside the box. Thank you.
Thank you. Mr. Dagley.
Thank you, Madam. It was just really a question for the council on, I see there the changes to the wording they're proposing for under paragraph 28 of their Matter 5 statement about minimising disruption, but it does seem to accept there will be disruption, and clearly that's a major concern for the Conservatives given the issues of traffic through the forest already, particularly people trying to find parking in car parks like at Thaden Boys, perhaps coming from quite a distance away because of the cheaper fares. I'm not quite clear how this will be dealt with by these statements. There's obviously a construction management statement, but it's really the transport assessments. Presumably these will be project level transport assessments, and I'm just wondering whether there will be any integration with the plan level transport assessment that we have currently, and whether there will be another iteration from Essex County Council once we know more details about how these car park disruptions might take place and what sequence they might be in. Thank you, Madam.
Does the council want to come back on the points made by Mr. Dagley and Mr. Lowry?
I think as far as additional transport assessment, it will be for the site promoters to show how they're going to achieve that via the planning application process. Insofar as not imaginative enough, we are going to be doing some further work around sustainable transport. We are going to be putting onto the evidence-based document from with an agreement from Essex County Council that sets out the measures we're going to be looking at in relation to Epping and North Weald Bassett.
And again, just as we discussed this morning in relation to the open spaces, could you just give us a sort of rationale for seeking to fit residential development into these car parking areas? There's obviously an acceptance by the council that the parking itself needs to be retained, and so it's not that you're losing car parking spaces as such. So why put housing there rather than perhaps on the edge?
For the same reason with the open spaces, seeking to maximise development within existing settlements and on previously developed land or brownfield sites, and not go into the green belt more than necessary. That's one of the key things that came out of the various consultations we've done with residents dating back from 2010, 11, 2012, 2016. It's been a consistent theme and message to not use up more green belt than we need.
Thank you. Okay, just before we move on to issue 2, is there anything final on issue 1 that someone had forgotten to say? Mr. Williams, Mr. Bolton, and then we'll move on to probably issue 4 if no one wanted to talk on issue 2. Mr. Williams.
Okay. Thank you, Ma'am. Apologies, I should have raised a point earlier on the modification to remove the sequential approach from policy SB2A. I think the basis of this sequential approach is sound. I don't think it's been properly, implemented. So the basis is sound in terms of directing development to areas of the lowest flood risk and lowest value to the greenbelt. I think what I'm concerned about is that by removing that sequential approach from the policy, it diminishes the value and the weight that can be attributed to that sequential approach. As we heard in earlier sessions a few weeks back, there are concerns about the robustness of the council's housing target. They've already got a shortfall of over 1,700 homes in the first 3 years of the plan. There are concerns about the ability of sites at Harlow to deliver at pace and scale, and we've heard this morning that there are still unresolved heritage issues around some of those sites. There are concerns, therefore, that the Greenbelt policy, the Greenbelt boundaries, as proposed, aren't able to meet the current need, and certainly won't be able to meet needs stretching beyond the planned period. So I think it's likely that the council will need to identify further sites. That sequential approach is sound, and it will be required to identify further sites. I think I'd just like to reiterate that our client's land at SR 0112 remains available. It could be safeguarded to meet future needs stretching beyond the planned period if it's not needed this time round.
Thank you. Mr. Bolton.
Can I fully support what's just been said? One could look at SP2 proposed removal critically and say well, it's being removed because we know it's not being followed. Certainly if it had been followed in North Wheel Bassett, then the site to the south of North Wheel Bassett identified by their master plan would have remained as an allocation, and it hasn't. So yes, we support that. I have another issue that came from your comment, and I'll raise it, and if I've misunderstood you, I won't go any further with it. And it was just at the close of the last session, you expressed something along the lines of you were concerned by where sites were being excluded because they'd been assessed as part of a larger site, which was not the scale of the site that's being promoted. But you then said you might accept that sites could be just excluded on a broad policy basis.
No, what I wanted to understand was what had been done. I won't want to express a view as to whether I agree or disagree, but I can understand perhaps the rationale for why a policy basis might lead you to a particular decision, whereas it would seem odd to say that a site flooded when it didn't, because it had been classified as part of a larger parcel. And whether I agree with them or not, I haven't decided yet. But I can see a rationale for for excluding a whole bunch of sites because they happen to be on the edge. But I couldn't perhaps see a rationale for saying that a site which didn't flood did, just because it happened to be.
Could I
within
just
that larger
comment
parcel. Yes.
briefly on that? Because I mean, to some extent, it taking up your flooding analogy. Firstly, the way it's been undertaken is if you like, the broad level of exclusion has been established by looking at much larger sites and their impact. So you're not comparing apples and apples here. So smaller sites within those do not share the same characteristics. And again, if I could use south of North Wheel Bassett as an example, I encourage you to do a site visit of the master planned suggestion down there. That is a radio station, which is not under cultivation, and a part of a golf course. Now, those two, if you like, landscape areas are completely and utterly different from the wider landscape that was assessed in order to establish the preference. And what's being said to you by Arab is they have similar characteristics. I would just ask you to go and have a look and see whether they do, because I don't think that's true. And I think there's a real problem with that in terms of your SA and whether or not, when you've got a smaller site which has distinct characteristics and has been assessed as part of a master plan exercise, to then say it's not a reasonable alternative and you don't have to assess it and you just write it off right at the beginning of the process, I don't think meets the test of reasonable alternatives, which requires you to actually assess them to the same degree. So I think it does need, I think you have problems, to be honest.
Thank you. So we'll move on now to, can I just confirm that there was nobody that wanted to say anything about issue 2, gypsies? No. Thank you. Okay, so we'll move on to issue 4. Okay, that's... Thank you, Mr. Coleman. We have Mr. Dixon and Mr. Saar back. Thank you. we heard this morning about the level of financial contributions that the viability study makes allowances for generally across the district, and also in the garden towns and the other strategic allocations. Happy to take any comments going around the table on that. But I'd be particularly interested, perhaps, if Mr. Coleman was sort of clarifying at the end of the session about the potential implications of paragraph 57 of the new NPPF, which sort of largely fixes viability considerations at the plan-making stage. Perhaps if you could summarise your position on that again, I think that would help me if we could maybe start with that. And I just want to understand the council's position as to how, if you think it does, how the plan needs to change to reflect the upcoming work in relation to the garden towns and more widely. I think you were saying your position is that there is enough evidence to say that the plan is sound with what we have, but you seem also to be proposing to take more evidence into account in order to potentially trigger paragraph 57 of the new NPPF. Certainly in relation to the garden towns. I'm afraid I wasn't clear in relation to the rest of the district. So perhaps if you could clarify that, and then we'll take any comments on any of those aspects around the table.
Okay, thank you, Madam. I won't reiterate everything I set out this morning, but I will, as you've asked, just give an overview of the position from the Council's perspective. Because I think the context is unusual and potentially quite complicated. In terms of the work that's been done to support the local plan, the council feels that the work which is set out in the viability assessment stage 2, EB 301, is sufficiently detailed and robust for the purposes of the local plan. I won't talk, unless you'd like me to, I won't talk about the funding gap issue, just about the nature of the work itself and the intention in terms of paragraph 57. Sorry. So as things stand, the work that supports the local plan, as I said, is the local plan viability study. And that sets out, based on a large number of assumptions and assumptions on developer contributions, it sets out what is likely to be required and deliverable. The IDP itself sets out the costs in terms of infrastructure projects and funding identified from those sources. The IDP does not seek to allocate specific developer contributions to individual sites. For the Garden Town Infrastructure Delivery Plan and Viability Study will provide further details of specific developer contribution requirements and the associated viability for the Garden Town sites, covering East Herts, Harlow and Epping Forest districts. Both those documents are being finalised at the moment, and it is intended that the reports will be available for publication the week commencing the 15th of April. That would mean that they would be available in advance of the Matter 14 hearing session on the 23rd of May. The position for the rest of the district is slightly different. For the site allocations across the rest of the district, the council is continuing to refine the apportionment of developer contributions required through planning obligations, and that will supplement the IDP. The IDP topic paper already supplements the IDP, that's EB 1101C, and that provides a high-level framework for apportionment and pooling arrangements. Addenda to the IDP topic paper are currently being finalised, and that will set out the apportionment of developer contributions associated with education and highways mitigation requirements. That is currently subject to engagement with the developer forum, and again is intended that they will be published in the week commencing the 15th of April. and they would then be available in advance of the Matter 14 hearing session on infrastructure and delivery taking place on the 23rd of May. Recognising the iterative nature of infrastructure planning and the importance of front-loading the development management process by providing as much clarity as possible on matters of viability in advance of planning applications, the Council also intends to undertake further viability modelling for sites across the rest of the district, that's those outside of the Garden Town, and that would supplement the existing studies undertaken by Dixon Searle. So that work has not yet been commissioned.
And that would draw site-specific conclusions?
The intention is that that would draw site-specific conclusions. So it would be akin to the work that's being undertaken for the Garden Town in terms of a viability study. But as things stand, the work on the viability study for the Garden Town will take the viability evidence for the Garden Town up to a more refined, detailed level than it will for the rest of the district. The Council does not consider that the further work, either for the Garden Town or for the rest of the district, is required in order to reach the conclusion that the plan's policies and allocations are deliverable, as required by paragraph 173 and 174 of the NPPF 2012. In fact, the Council is confident that the available evidence clearly demonstrates that the cumulative impact of standards and policies will not put implementation of the plan at serious risk and should facilitate development throughout the economic cycle. And that's the test in the NPPF. However, we do recognise that the further work I've outlined will be beneficial in order to respond to the revisions made in the NPPF 2019, and that's paragraph 57, and to provide a robust and clear basis for decision making at the development management level. So just to summarise, for the district there are two levels of work and two different geographical areas, essentially. The viability study and the IDP that support the local plan cover the entire district, including the Garden Town, and we feel that those studies adequately justify and demonstrate the soundness of the local plan under the NPPF 2012. There is then a further layer of detail above and beyond the evidence to support the local plan. For the Garden Town, that's the Garden Town IDP and the Garden Town Viability Study, which is currently being finalised, has been subject to ongoing engagement with site promoters and stakeholders, and will be available in mid-April. That's also will be provided to the inspector undertaking the Harlow local plan examination at the same time. So this is something that's been discussed across the Garden Town partner authorities. So that will become available, and we believe that will provide sufficient evidence to essentially trigger paragraph 57 of the NPPF in terms of that providing a robust basis for determining planning applications under paragraph 57 of the NPPF. Sorry, 57, that's correct. For the rest of the district outside of the Garden Town, there is supplementary work also being undertaken, but that work is, whilst it's consistent with the work of the Garden Town, it's at a different stage. And that largely is because there are so many site allocations across the district. It's a very complex picture. We understand what the requirements are at a settlement by settlement level, but we haven't yet completed a breakdown of apportionment of developer contributions to individual sites. And to do so is difficult and arguably beyond the scope of what you would normally do. So what we are doing is trying to provide as much detail as possible about what likely requirements will be for sites. At the moment we're doing that for highway mitigation measures and education requirements, and that work is currently subject to consultation with our developer forum and will be available by mid-April. And then the council is also committed to undertaking further viability work that will supplement the existing work undertaken by Dixon Searle for the local plan. And that work will assess the new IDP work that's coming forward in a more site-specific level. And the intention is that that would be capable of providing further clarification on and provide a robust basis for decision making at a development management level in accordance with paragraph 57 of the NPPF 2019. There's also, I said, the IDP work that's being progressed at the moment. The more detailed level supplements existing IDP, but it only relates to highways, mitigation and education. We are also committed to doing further work on sports provision, and that's subject to, or that's included within the the Statement of Common Ground with Sport England, and that work is progressed but hasn't yet been concluded. So that's running slightly behind the other two areas. There may, of course, be other areas that the council needs to do further work on across the district, such as, for instance, apportionment of sustainable transport costs. At the moment, the highways work is purely the physical highways junction mitigation, as opposed to new bus routes, new cycle routes, etc. So there may be other areas that need to be supplemented as well. Thank you.
So to take that one step further then, thank you, that's helpful to outline what you're doing. If we take the Garden Towns evidence to start with, which I think you're saying you think would be sufficiently detailed to trigger paragraph 57 of the NPPF, and it will be available within the time frame of this examination, what needs to happen to the plan? What needs to happen in terms of consultation, engagement, whatever, and what needs to happen to the plan to give that the status it needs to trigger paragraph 57? And then we'll deal with the rest of the district.
Thank you, Madam. I think this is actually a question that you've asked for the session on Thursday for the Garden Town communities, but I'm very happy to seek to address it now. Modifications are likely to be required to the local plan to make clear of the status of the emerging evidence for the Garden Town, and also to reflect any conclusions or recommendations arising from the work. So, for instance, if the viability study for the Garden Town were to conclude that a lower level of affordable housing should be required on a particular site to ensure it's viable, then the council would seek to make a modification to reflect that. That's not the direction of travel at the moment, but obviously we await the final documents. And I think it will also be important to make modifications to make clear that the work is intended to essentially trigger paragraph 57. That's certainly been the intention of the Garden Town authorities in the work we have been undertaking jointly on the studies. And there has been extensive engagement with the landowners and site promoters of the Garden Town communities in relation to the emerging work, which has included face-to-face meetings and also allowing informal comments to be made in writing back to the parties on the work. So it has been robust, it has been a very comprehensive approach. So to answer your question, I think there will need to be some modifications made to the plan once the documents are available. I already feel that key parties in terms of infrastructure providers and stakeholders in terms of landowners and site promoters have been engaged with fairly comprehensively throughout the process of the preparation of the documents.
And how about anybody else present? How would anybody else who hasn't been involved in that comment if it was going to, would it be through the main modifications process?
Yes, absolutely. Also, the intention is that by having documents available in time before hearing statements need to be submitted for the Matter 14 hearing, there would be some time for anyone to make comment within their hearing statements if they're participating in that hearing. but certainly through the main modifications consultation that will follow the hearings, there would be a further opportunity for anyone to make comments.
Thank you. And if you can now answer the same question in relation to the rest of the district evidence.
I think for the rest of the district, it is a slightly different position. I think that the emerging work on the IDP may require some minor amendments to the plan, although I don't anticipate them being very significant, because the work that is being undertaken simply supplements the existing IDP and the existing requirements that are already set out in the plan. And I think that it will be important that the plan retains enough flexibility and is not too prescriptive about how individual infrastructure projects are delivered and how the funding is apportioned between different sites. So the work that is emerging does make that clear. It's not intended to be prescriptive, but it is helpful in providing a guide to all parties on what infrastructure contributions are likely to be required, and therefore how infrastructure should be funded and delivered. So I think there will need to be some minor amendments in relation to that. In terms of paragraph 57 of the new NPPF, there is a question which I don't think I can answer today in relation to whether the existing evidence that supports the local plan, which is the Dixon Searle work, can provide a basis for, in itself, for the application of paragraph 57 of the NPPF, and whether that may simply be supplemented by further evidence that the council will undertake to produce on viability. At this point in time, it's difficult for me to give timescales for completion of the work I've outlined on viability for the rest of the district, and therefore whether that would be available. Certainly don't anticipate it would be available by May. It doesn't mean to say it couldn't be available in time for main modifications consultation, but at the moment I can't confirm timescales for that. So I think we recognise that there is a difference in the level of the evidence, or there will be a difference in the level of the viability evidence of the Garden Town as opposed to across the rest of the district. But it doesn't mean to say that the work undertaken by Dixon Searle will not be capable of providing the necessary benchmark, if you like, that paragraph 57 of the NPPF requires.
And what will you need, what do you need to do to be able to answer that question? You can't answer that question today. What are you going to do to answer that question?
We can certainly take it away and seek to provide more clarification on our position. Okay. I think it's difficult because obviously paragraph 57 of the NPPF is new, and therefore it's difficult to, there's not much of a barometer at the moment in terms of the level of evidence that's required to trigger it and the detail of the evidence. But I think it's fair to say that the evidence that is available, is not already available, sorry, to support the local plan, is not going to be significantly different to any further work that we do. It's very likely that any further viability work that's undertaken will use the same basis and the same basic assumptions that are fed into the work. The big difference is applying different infrastructure costs to the sites which arise from the apportionment. But it may well be possible to do that without necessarily, you know, there are different ways of doing it, and it will build on the work that's already been undertaken. I don't know if you want to add anything on that.
Thank you. I'm not sure that I need to add much, but I think that's right. I think this morning you mentioned sort of a tying up of the viability work with the developing picture on infrastructure, and I think that would probably be the key element. I have to say, I think looking at because it's not just in our terms, it's not just a case of looking at the NPPF, it's also the planning practice guidance on how does one go about preparing viability evidence both at plan making and decision making stage. And I think if you refer to that, I don't think there's too much missing. I think probably the key bit may well be the tying up with the latest picture on infrastructure, and any updating around, you know, market changes, new information. But I think there's a good base of information there, and I don't think the gaps are going to be that great, just as a sort of view today.
Thank you. Okay. Thank you. If we take Mr. Lowry, and then Mr. Steele.
Thank you, Mum. As an amateur, it strikes me that we're being asked to comment and you are being asked to judge on matters which are still very much in progress. We looked at the cost of interventions which are part of the IDP. I'm sorry, I can't tell you which one. There are pages of them, so we focus just on this town here, and the interventions listed here go across 6 sides. It must be a draft. We deduce that. So many of them are going to cost in the order of exactly 1 million, but there are some very odd things. A piece of road between 3 and 10,000, but some new traffic signs for 500,000. What we did, just to try and get a handle on the whole picture, is we added the lot up. Now this is just for Epping Town, and all the interventions planned on this draft come to some £60 million. We then did some maths because we divided it by the number of houses expected on the plan to be built in the area, and that equates to some £45,000 per house. Now I'm sure you developers sitting out there will not be terribly happy about the idea of sticking another £45,000 on each house, like it's just a no-no. So there is a gap, and I presume the District Council must be working as part of what their ongoing activity is to find ways to plug that gap by seeking funding elsewhere or to reprice some of their intervention measures. But it's very hard to comment when we haven't got, you know, information that is fairly reliable. We're just working on a vague draft. Thank you.
Mr. Steele.
Yeah, thanks, Mum. On a similar vein, it's quite alarming that the council are looking to distinguish between dealing with the garden towns and then the rest of the district, because that only works, I suppose, if you're taking every site within the rest of the district as a smaller site. So to explain that, if you look at Ongar, for example, where on a similar vein, the IDP, which is reference EB 1101B, pages 73 onwards for Ongar, if you take the vision for Ongar and what the council are trying to achieve is to make it self-sufficient. So that means that you'll be bringing forward the residential alongside the infrastructure. Now, when you look at that list that is listed within Ongar, it doesn't, we've done a very similar exercise, you don't need a professional to do that. The number is way above the figures that were given this morning as what is acceptable in terms of that infrastructure threshold. But it also identifies, for example, 14 hectares of open space that doesn't have land that is even identified for that. So if you take that as it's also green belt, so it doesn't necessarily by default mean it will get consent for public parks, semi-grassland, leaps, laps, etc., and all of the sites are of a scale that aren't going to deliver that scale of infrastructure. So it can't be right that you should just take a distinction between the two, whether with further work for the garden towns and not for the rest of the district. And I know this might not be the session; it might be for Matter 15, but representations made consistently by the Ongar Neighbour Planning Group is their concern that this infrastructure that is listed, and whilst I note the comment that these aren't apportioned to specific sites, will clearly, to pass the SIL 122 test, to deliver this, it needs to be necessarily relevant and proportionate to those sites. So our concern is clearly that Ongar will not deliver its required infrastructure to meet the vision of which is to be self-sufficient, and that larger sites that were put into the site selection process that could have delivered the wider infrastructure were all discounted very, very early in the process for reasons that we've all heard today. Thank you, Mum.
Thank you. Mr. Bolton.
Thank you. It's probably a bit of an esoteric point, but my understanding is the plans being progressed under the transition arrangements under Power 214 of the 2018 framework. And the comments being made at the moment is how do you get the evidence base so it fits to paragraph 57 of the new framework, the 2019 framework. Seems to me you're cherry picking between the two frameworks. You know, you've gone to a big rush to get the thing submitted without a full evidence base in order to avoid paragraph 60 of the new framework, but are quite keen to have the regulatory and the status of paragraph 57. I don't think you can have, you know, you can't have one without the other. I think the framework's got to be read as a whole. You know, and if you're paying in aid the 2018 framework in order to escape paragraph 60 of the new framework, you then can't have elements of policy that are effectively trying to enact or incorporate paragraph 57 of the new framework. That seems to be very much cherry picking between the two. And
So what would be, so if the plan progresses and were to become adopted, what would be the alternative, given that paragraph 57 would apply to a planning application being assessed? What would be the alternative?
Well, paragraph 57 doesn't give full weight to a local plan. It has to be up to date. So therefore, this plan is being produced under the old system. It will not be up to date at that point. It's simple as that. I mean, it's a corollary of rushing something through under the old system. Is you're not going to be able to pay in aid some of the new policies in the new framework because you have not produced a plan under those policies.
Okay, so how would a planning application be assessed instead? What would be the result of it not being up to date in that sense?
Well, in that case, I think if you look at the... I think my understanding of how it would work is obviously the development plan would not have the status that paragraph 57 gives it to it, because that starts where there are up-to-date policies. Well, you wouldn't have up-to-date policies because you've not done that. It then goes to say it's up to the applicant to demonstrate whether particular circumstances justify a need for viability assessment at the application stage. I think that's where you go. You're going to go straight to doing site by site. Yeah. I know that sounds a little bit negative, but I don't think you can cherry pick between the two, or between the different paragraphs. Let's be honest, they're only 3 paragraphs apart. You know, paragraph 60 and 57.
What does the council say to that point about sort of essentially picking the bits you want to conform to and the bits you don't?
I don't necessarily agree. I mean, I think the 2012 NPPF is very clearly what the plan is being examined against and the soundness of it. But the point I've made today is really we acknowledge that the planning applications will be determined against the new NPPF, and therefore paragraph 57 will apply. And we want to be in the best possible position to provide the evidence to ensure that planning applications can be assessed against the viability evidence that's available. I think our position is fairly sort of open on that point.
Thank you, Mark. Just a very short point. I'm slightly alarmed, really, that this work is still ongoing, and issues of infrastructure delivery and viability are key to ensuring the deliverability of the current plan. I think what this demonstrates is a need for further flexibility and casts further doubt about whether the existing Greenbelt boundaries are capable of enduring beyond the plan period, but more so actually delivering the quantitative requirements in the current plan. So it just highlights the additional requirement for flexibility. Thank you.
Thank you, Madam. I think it's fair to say we've heard what's been said around the table. We're very happy to take it away and Obviously, we've got opportunities later on to discuss, not least matter 14, the hearing session. So we've certainly heard what's been said. Thank you.
Thank you. Okay, so we'll end today's session there then at, what is it, 5:40. Thank you very much for everybody's contributions, and thank you this afternoon for catching up on time this morning. Thank you.